We begin today's show with a guest here in New York who's been under an FBI gag order for the past 6 years. In early 2004, an FBI agent visited Nicholas Merrill and handed him a national security letter that ordered him to hand over detailed private records about some of his customers. At the time, Merrill was running an internet service provider in New York called Calyx. Under the USA Patriot Act, the FBI issued more than 192,000 national security letters between 2003 and 2006 in order to obtain sensitive information without a court order. Under the law, recipients of the letters are barred from telling anyone about their encounter with the FBI. While Nicholas Merrill was not the first American to be gagged after receiving a national security letter, an NSL, he was the first to challenge the FBI's secret tactics. After receiving the national security letter, Merrill went to the American Civil Liberties Union, which then filed the first lawsuit challenging the national security letter statute. In the lawsuit, Merrill was simply identified as John Doe. It was only this week, after reaching a settlement with the FBI, that Merrill has been able to come public to reveal his identity. Nick Merrill joins us here in New York. We welcome you to Democracy Now!
Thank you. Good morning.
It's good to have you with us. I bet it's good to be able to speak.
It is kind of a relief, yeah. It's also a bit surreal because I'm not exactly used to it yet, and almost every time I say something about it, I kind of have this knee-jerk reaction, like, I'm not supposed to talk about that, and you know, that got so ingrained into me that it's still a bit strange.
Well, in a moment, we're going to speak to a Connecticut librarian who was joined with your case for Connecticut librarians because they, too, resisted an NSL.
Yes.
But why don't you tell us your story? What day was it? When did it happen, and what happened?
I don't know if I'm allowed to, for some reason, say the exact day. It was in February 2004. An FBI agent visited my office. He brought me a letter. He badged himself, he identified himself as an agent, he gave me this letter. I opened it, I read it in his presence, and a few things kind of leaped out at me upon first reading the letter, one of which was that I was commanded to never tell anyone about the letter. Not that I had received it, not that there had been a request for information. It was a very broad and there was no exceptions in there. There was no instructions on how to appeal. There was nothing about contacting a lawyer. So I said to the agent at that time, it says here I can't tell anyone about this. Does that include my attorneys? Does that include my business partners? And the man said something to the effect of, I've just been given the job of bringing you this letter. I don't know. I'm not a decision maker. And that was basically the end of our conversation. Then he left. At that point, I was left with this letter, which asked for what I believe to be constitutionally protected information belonging to one of my clients.
You know, in the interests of full disclosure, we were one of your clients, and we worked with Calyx. We worked with you.
Yes.
Did the FBI ask about us?
I'm not allowed to really talk about the target of the investigation. That's, you know, I'm partially released from the gag order in that I can say I was the plaintiff in the case, it was my company, but I'm not allowed to say anything that would give anyone any kind of a hint, basically, as to which of my, 200-some clients it may have been about.
And Democracy Now! Was one of your clients. Who else were among your clients?
A lot of my clients had nothing to do with politics. They were just businesses. Some of them were really boring. They were household names, IKEA, Snapple, Ice-T, Mitsubishi Motors, things like that. But, then I also had a number of not-for-profit organizations, a number of NGOs.
Like?
Well, I mean, I don't know. I'd prefer not to mention names if it doesn't matter. But they're really boring, believe it or not, the New York Civil Liberties Union was one of the clients I was most proud of.
And so what did you do? You did, in fact, contact your lawyer, though you didn't know if that actually was violating the NSL.
According to the, to a strict reading of the letter, it seemed to be a violation of what they were telling me. It said, do not tell anyone. But I basically took a leap of faith, feeling that I'm an American, I always have the right to talk to a lawyer, and I don't believe there is such thing as you can't talk to a lawyer. So the first thing I did basically was call my personal attorney, and then he and I ended up going over to the New York Civil Liberties Union at first, and then later we were connected to the American Civil Liberties Union. So yeah, I mean, that was a leap of faith, because, you know, the letter said, do not tell anyone, but basically the first thing I did was tell someone.
Now, how did you decide to sue, to resist the NSL, not to hand over the information?
You know, it was my gut feeling that to do a search, you know, I'm not an attorney, but I know a bit about the Constitution, and my understanding is that the government needs to prove probable cause and go to a judge in order to search. You know, one of the things that leapt out at me about this letter was that it was not signed by a judge. It was signed by someone from the FBI. You know, it seemed to me that that undercuts the whole system of checks and balances that we have, and I didn't believe it was legal. And I had been reading about, you know, all the new powers under the Patriot Act, and it just seemed to me that I didn't have much choice but to say something about it.
We're going to break, and when we come back, we're going to be joined by one of the 4 Connecticut librarians who are joined with your case.
Great.
Because, like you, they resisted the FBI's call and sued the U.S. government. We're talking to Nick Merrill, president of the internet service provider Calyx, filed the first court challenge to the FBI's national security letters in 2004. Stay with us. War by Hypnotic Brass Ensemble. This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman. Our guest in his first national broadcast interview is Nick Merrill. He has just gone public after being gagged for 6 years, having received a national security letter from the FBI, and the first to challenge it, to sue the U.S. government. Well, I also want to bring into this conversation someone else who was gagged by the FBI after receiving an NSL. George Christians, Executive Director of the Library Connection, a consortium of libraries in Connecticut. He joins us from Hartford. George Christian, welcome to Democracy Now! I'm sure as Nick spoke, it sounded familiar. Tell us what and when it happened to you.
It happened to us in 2005, and actually it was thankful that we're thankful that Nick made his protest. One of the problems is when the FBI comes, part of you says, well, it's the FBI, let's give them a hand. I had never heard the words national security letter before. I asked our attorney what a national security letter was. She had never heard the words before, but thankfully one of her assistants was able to do some research and find Nick's case and find that a judge had declared that the statute was unconstitutional because it violated the First, Fourth, and Fifth Amendments of the Constitution.
But George, could you step back a second? Could you step back a second and tell us,
yes,
when you were handed that national security letter, where were you? Who came to your door?
It was July of 2005, a year after Nick received his. The 2 FBI agents came to our office with the letter. They had called a week before and told us that they were going to serve us with a security letter. The thing that leaped to my attention about our letter was that it concerned an incident back in February, 5 months prior to this. It was dated in May, 2 months prior to July, and it was still addressed to the wrong person at our office, although they had called to ask who it should be addressed to. So I could conclude that it was not a case of hot pursuit, and that if I dug my heels in, we weren't jeopardizing any of our fellow citizens.
What did you say to the FBI agents who came to your door?
I said it was my understanding that a federal judge had ruled the statute authority they were using to be unconstitutional, and I would just like to talk with my lawyer. And the agent said, fine, wrote a number on the back of his business card and gave it to me. He said, have your attorney call this number, and they left.
And so you
It was only after I called.
You called a meeting of the executive committee of the Library Connection. And the Library Connection, what, is a consortium of the libraries of Connecticut, the internet system that you use?
Yes, we are owned by 26 libraries in the Hartford area, 27, one academic, 26 public. And our basic function is to provide IT services to these libraries. We run a common computer system for them so that they can share data amongst themselves, do interlibrary loans, share patron data.
So you decided to sue the government.
I decided that I was not going to participate in the violation of the Constitution, but I did want the approval of my, at least executive board, because at that time I thought that a suit against the Attorney General of the United States might cost a lot of money, and I didn't feel I had the moral right to put their money at risk without some indication that they wanted to do this as well.
Because you were gagged.
But because we were gagged. But fortunately, they were on board as well, not only from constitutional point of view, but there's a long tradition. 48 of the 50 states have explicit statutes guaranteeing the sanctity of patron records and mandating that librarians take active measures to preserve the security of these records. So that federal law does trump state law, but they came from a long tradition of just saying no without a court order.
I don't know if most people think of librarians as the freedom fighters of our time, but here you four, the four librarians of Connecticut, took on the USA Patriot Act. This, just before this, at the time, Attorney General John Ashcroft, you sued Alberto Gonzales when he became Attorney General, had called librarians hysterical, said this wasn't happening to libraries. And yet, while you knew it was happening, you couldn't say it was happening.
Yes, that was extremely frustrating. The Patriot Act was up for renewal in Congress, and we at least wanted to go to Congress and tell them what had happened and ask them to redress this in the renewal. And I'm sure the gag order was maintained explicitly to prevent us from talking to Congress.
And so your case was joined with Nick Merrill's. You weren't even allowed in the first courtroom, is that right? When your case was being heard?
Yes, when we first sued the Attorney General, I told our attorneys I'd like to be in the courtroom. After all, I'm the plaintiff. And they said no. They had talked to the judge that would not be allowed because then our identity could be guessed. But the judge did allow us to go to a courtroom in Hartford, 60 miles away, where we were locked in a room with a security guard and able to watch our case on a monitor. But as the plaintiffs, we were not allowed in the courtroom.
Ultimately, your gag order was lifted.
Yes.
But what happened to your case?
Well, after the statute was renewed, it was modified significantly in the renewal, and the appellate court ruled that we had to go back to the